So today I will talk about the United States Constitution, the 7th and 8th Amendments. The 7th Amendment states, in suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. When I use brown text, that's a direct quote from the document. So this consists of these elements: common law suits, civil trials rather than criminal trials, the right to a trial by jury, and that facts found to be true by a jury are not to be questioned by a court. So let's look at this in more detail. So some historical background on the right to trial by jury. Jury trials were the norm in criminal cases under common law, and this is protected under Article 3, Section 2, and the 6th Amendment, which we talked about last time. Jury trials for civil suits were discussed at the Constitutional Convention, but someone proposed that jury trials for civil suits be included, but there were a lot of differences between the various states. So even though 12 states protected the right to a civil jury trial, there were enough differences that they couldn't come up with a phrase that encompassed all of these differences between the states. So they dropped the matter. And that was kind of a large oversight. So because of this, the Anti-Federalists argued that juries for civil trials would be abolished and used this as an argument against the Constitution, because the Constitution guaranteed jury trials for criminal cases, and the Anti-Federalists said, well, if they only guarantee it for criminal cases but not for civil cases, that must mean they want to abolish it for civil trials. So this was an argument the Anti-Federalists used against the Constitution. If we look back at the Declaration of Causes and Necessity of Taking Up Arms, which the Second Continental Congress wrote in 1775, they said, statutes have been passed for extending the jurisdiction of courts of admiralty and vice-admiralty beyond their ancient limits, for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property. So the admiralty courts were courts of admirals dealing with maritime problems, and that was fine, but then the British had started expanding their use of admiralty courts to things that didn't involve maritime issues, and admiralty courts didn't have jury trials, so the colonists were upset at that. And we see here that they were complaining both about, in cases affecting both life would be criminal cases and property would be civil cases. One complaint against the king in the Declaration of Independence said, for depriving us in many cases of the benefits of trial by jury. So we can see that jury trials were an important bulwark of protecting liberty for the colonists, and that wasn't something they wanted to give up. So it starts out in suits of common law. So let's first look at common law versus equity courts, so we understand what common law means. English law first developed common law, and this was back as before the 1200s even, that common law was developing. It's an accusatory system based on specific charges. So a specific charge is brought and someone is accused of that particular charge, and then the case is brought in before the judge. And common law is based on precedent or case law. So previous decisions by judges would affect future cases. And often the verdicts are decided by a jury. And the compensation that the common law court could require would be either monetary or the return of property. But that was kind of the limit of what they could enforce as a judgment. And it would have a judge presiding, but the jury, the 12 men would decide the verdict of whether someone was guilty or not. So this system worked pretty well, but there were some deficiencies in it. So to cure these, people would appeal to the king for justice, because the king was seen as the font of all justice. So if the court system didn't provide justice, then you appealed to the king. So this led to courts of equity. The king, I guess there were too many petitions, so he says to his chancellor, who was his chief minister, you take care of this. So he delegated to the chancellor. The chancellor, I guess, became tired of this too, so he started the Court of Chancery about the mid-14th century. So this Court of Chancery became a court of equity. So it was somewhat like an appellate court, because you would first go to the common law courts and you would fight your case there, and if things didn't work out fairly, then you would apply an appeal to this Court of Equity, this Court of Chancery. So the judgments in the Court of Chancery were based on fairness stemming from natural law, whereas the common law was based on precedent or case law. And the remedies that the Court of Chancery could give included injunction, stopping someone from doing something, or performance of a contract, force a person to carry out what they agreed to in a contract that they had signed, or maybe a return to a previous situation. So they had a wider range of remedies that they could apply than common law courts. And in these courts of equity, usually the verdicts were determined by a judge. They weren't jury trials. So it was kind of a parallel system of courts that, kind of cured some of the deficiencies of common law. So common law were the main courts, and then you had this separate court of equity that would kind of function somewhat like an appellate system to bring fairness to the outcomes. In Article 3, Section 2 of our Constitution, it says, the judicial power shall extend to all cases in law and equity. So the in law is common law, and equity are these courts of equity. So in the American system of justice, both law and equity courts are combined into a single court system. But we still have this idea of, common law and equity law that are kind of parallel ways of administering justice. So we combine them into one system, but we still have this concept of kind of two different ways of coming to justice. So back to the Seventh Amendment, it says, in suits at common law, so we just examined common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. So a value of $20 back in 1791 would be worth over $600 today. And today, we actually go over that. We have small claims courts for smaller disputed amounts. It varies by state, but often it's up to 5,000 or 10,000. Few states up to 20 or 25,000, but a few thousand you would go to small claims court. And today, to file in federal court, the disputed amount must be over 75,000. So we've gone a little higher in the dollar amount, but we do still have this distinction between, if it's a large enough amount, you can have a federal court case. And the disputes would be over monetary or property or liability, breach of contract, discrimination, employment-related issues, etc. So these are civil, they're not criminal cases. So that's the distinction, that the Seventh Amendment is dealing only with civil cases. The Sixth Amendment that we covered last time dealt with criminal cases. And the remedies that in civil cases include monetary damages and preventing certain acts, or forcing, say, a person to carry out a contract that they have signed. So the Supreme Court says this applies to the kinds of cases that existed under the English common law when the amendment was adopted, in the case of Baltimore and Carolina Line versus Redmond in 1935. So the Supreme Court has kind of limited it, so saying that only those sorts of cases that existed when it was passed does it apply to. So if there's new types of cases, they might not apply this amendment to them. So in that sense, only the Seventh Amendment and the grand jury requirement of the Fifth Amendment are not incorporated through the 14th Amendment to apply to the states. So the 14th Amendment has allowed most of the Bill of Rights to be applied not only in federal law, but to the states as well. but the 7th Amendment here and the grand jury in the 5th have not been applied to the states, although most states voluntarily allow civil jury trials, even though the Supreme Court has not said the Constitution requires it. So let's look at some differences between criminal and civil cases. So in criminal cases, the offense, I mean, it's probably a crime is committed against a person, but it's considered to be against society. You know, if your behavior is criminal, you're breaking society's rules, society's laws. So the state will prosecute the criminal. The state's attorney will prosecute a person who breaks the law. Whereas in civil cases, the private party that's injured will sue. So it's not the state's attorney that will sue. It's a private party will bring a suit against another private party. So it's up to you to enforce your civil case in this. You can bring it to the court, but it's you bringing the case. It's not the state is going to prosecute for you. In criminal cases, the defendant is guaranteed a lawyer by the 6th Amendment, as we saw last time. But in civil cases, everyone pays their own lawyer. You don't have any guarantee to a constitutional guarantee to a lawyer in civil cases. So if you want to bring a suit against someone, that's fine, but you have to pay your own lawyer, and in their defense, they also have to pay their own lawyer. So no one gets a free ride on the lawyer in civil cases. But as we saw last time in the 6th Amendment, if you're a defendant in a criminal case and you can't afford a lawyer, the state will provide you with one. The burden of proof is also different. So in a criminal case, you're required to prove beyond a reasonable doubt. So the jury is evaluating the evidence to decide if beyond a reasonable doubt that the person committed the crime. In civil cases, there's a lower standard of evidence. It's the preponderance of the evidence. So preponderance, more likely than not, more than half, but it's a lower standard than beyond a reasonable doubt. Presumably because in criminal cases, your life or your liberty is at stake, whereas in civil cases, it's only a monetary issue. So because there's heavier punishments in criminal cases, you have a higher standard of proof required. So, which takes us to the next point of punishment. For criminal cases, it could be prison time or a fine or death for serious crimes. And in civil cases, it's just monetary damages or to force or prohibit an action, say carrying out a contract, a clause in a contract that you've signed, or to stop you from doing something. So it's less serious punishment. And so criminal cases have more constitutional protections, like the 4th Amendment prohibiting illegal searches and seizures. And in civil cases, there are cases where you can face both criminal and civil charges for the same act. Maybe a famous one of this is that O.J. Simpson was put on trial for murder. He was found not guilty for murder, but he was also civilly charged for wrongful death, and there he was found guilty and liable to pay $33 million. So one act, and he was found not guilty in the criminal case, but he was found liable in the civil case and had to pay monetary damages. So one act can bring both civil and criminal charges. And the 7th Amendment continues, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. So again, we see common law coming up as opposed to equity courts. Article 3, Section 2 of the Constitution says the Supreme Court shall have appellate jurisdiction both as to law and fact. So this phrase alarmed the anti-federalists who thought the court would overturn jury findings. So you have questions between law and fact. So questions of fact include determining the liability or damages or punitive damages. Questions of law are what does the law say? What's according to or against the law in this particular case? So the Seventh Amendment was proposed to answer the fears of these anti-federalists that thought courts would overturn jury findings because they felt that juries should have the final word. If it's a question of fact, like is someone liable or not in a case, or what should the damages be? They thought the jury, they have their say, and the court should not be able to question what the jury decided. So they wanted courts to only review questions of law. What does the law say in this matter, not jury findings of fact. In the case of Gasparini versus Center for Humanities in 1996, the Supreme Court allowed an appellate court to review a jury award for damages that were considered excessive. So that was a kind of break from this, that it allowed an appellate court to examine a jury finding of fact, in this case, the amount of the damage. So that was a weakening of the Seventh Amendment. The Eighth Amendment, we'll move on to the Eighth. It states, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So no excessive bail works in conjunction with the Speedy Trial Clause of the Sixth Amendment and the right of habeas corpus, which is in Article 1, Section 9, Clause 2, which says the privilege of the writ of habeas corpus shall not be suspended. So these three together work to prevent unnecessarily long pretrial confinement, because that could be abused by the government. The English Bill of Rights in 1689 had these complaints about the former King James II. It said, and excessive bail hath been required of persons committed in criminal cases to elude the benefit of the laws made for the liberty of the subjects. So saying that excessive bail basically infringes on the liberty of the subjects because it keeps people in prison when they should be allowed out on bail. Also, and excessive fines have been imposed and illegal and cruel punishments inflicted. So these were some of the complaints they had against King James II. King James II was basically overthrown in the Glorious Revolution of 1688, where the English made James II's daughter Mary and her husband William of Orange the new king and queen. So then you had King William and Queen Mary. And so they came up with this list of excesses of King James II in their Bill of Rights, so that wouldn't be, the king wouldn't stomp on their rights again. So that was the English Bill of Rights, which we see that this wording has been brought forward to our Bill of Rights. Also, fines as punishment are not meant to ruin someone financially. That could be a way to abuse someone's rights as well by ruining them financially with an excessive fine. So it continues on, nor cruel and unusual punishments inflicted. So again, from the English Bill of Rights, which required that excessive bail ought not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. So we see that the wording from the English Bill of Rights is very similar to what we see in the Eighth Amendment here. So this limited the king to only punishments that Parliament allowed. If the king couldn't be creative and come up with his own torturous punishments, what have you, he could only administer the punishments the Parliament allowed. The Glorious Revolution, in addition to bringing William and Mary, basically established that Parliament was superior to the king and had say over what the king could do. In 1791, when the Bill of Rights was proposed, this no cruel and unusual punishment was viewed as banning torture as punishment. And then in O'Neill versus Vermont in 1892, unusual was taken to mean respect for ongoing tradition and humane treatment of criminals. So we see that the Supreme Court was reading this phrase and trying to decide what cruel and unusual punishment meant. The concept of proportionality comes from Leviticus 24:17 through 21, which states, anyone who takes the life of a human being is to be put to death. Anyone who takes the life of someone's animal must make restitution, life for life. If anyone who injures their neighbor is to be injured in the same manner, fracture for fracture, eye for eye, tooth for tooth. The one who has inflicted the injury must suffer the same injury. Whoever kills an animal must make restitution, but whoever kills a human being is to be put to death. So often today we might see this as being too harsh, but actually this was not meant to be harsh treatment, but to be proportional treatment, so that you wouldn't have some minor infliction, some minor transgression, and then have a punishment for that crime that was way out of proportion to what the crime was done. So this is saying that the punishment must fit the crime. And the Supreme Court has applied this principle in allowing death penalty for some murder cases, but denying it in the case of Coker versus Georgia in 1977 for rape, saying that if the criminal did not take the life of the victim, the criminal's life should not be taken. So they were saying, you know, what the punishment has to fit the crime. So if you didn't take the life of your victim, your life shouldn't be taken either, which is going back to this biblical principle of proportionality. Other cases that apply this proportionality principle are that citizenship cannot be stripped for desertion from the army, or inhumane prison conditions and serious harm caused by prison officials are also prohibited. So we see that this biblical principle has been applied by the court in multiple cases. So in concluding, the Seventh Amendment provides for jury trials in civil cases. Jury trials were seen as very important protection of liberty by the founders, were mentioned in the Declaration of Independence and the Constitution. Civil trials being omitted from the Constitution was a big cause of concern for many of the anti-federalists, which they used as an argument against it and a means of proposing the Seventh Amendment. It applies to common lawsuits rather than equity claims, and facts are to be determined by a jury and not re-examined by the court. So the jury has independence and final say on facts, who's guilty or not, or what damages should be. Today, this has been somewhat limited in scope by the court. And on the Eighth Amendment, it's taken largely from the English Bill of Rights. It prohibits excessive bail and fines and prohibits cruel and unusual punishment, and also incorporates the proportionality principle that punishment should fit the crime. That's what I have for today.
Because the flag still stands for freedom, and they can't take that